Morning, everyone. Today's session is on business law for managers. That's the unit we'll be doing today, and my name is Shazia Khan. Today we'll be doing learning outcome 2. The last learning outcome we did was learning outcome 1, which was to understand generic business law. So before I go into learning outcome 2, I want to be able to give you a recap of what we did in the last session. So the last session was to understand generic business law, and it was learning outcome 1. We looked at protecting rights. We looked at dispute resolution, consumer protection. We looked at principles such as company law. We looked at key areas of business law, things like contract law, employment law, company law. We looked at intellectual property, consumer protection laws, competition law, and tax law. We looked at how a business is formed and structured, so the different forms a business can take, things like sole trader, partnership, or limited company. We also looked at regulatory compliance for businesses to comply with any legislation such as GDPR. We'll also be looking at that a lot in learning outcome 2 as well. We looked at dispute resolution, things like litigation, arbitration, mediation, and we also looked at contracts in business law, things like offer and acceptance, consideration, and capacity. We then went to look at explain why it's so important to have business-related laws and the legal framework around that. We looked at protection of rights in learning outcome 1. We also looked at dispute resolution, consumer protection, things like product safety, fair trading practices, and remedies for consumers. We also looked at elements explaining the principles of business law. So we looked at company law, what it was, key aspects of it, and how it applied to businesses. For example, the Companies Act 2006. We then went on to look at common law and also civil law and criminal law as well. We looked at statutory law in regards to businesses and how it's created by legislative authorities, and it's laws that are codified and that must be followed. An example was Data Protection Act 2018. We also looked at elements of differentiating between civil and criminal law. So what the purpose of civil law is, the legal action, the outcome, the burden of proof, and examples of that both for criminal and civil law. We looked at scenarios where we looked at how to differentiate between civil and criminal law. And we looked at an example of a scenario in civil law and how that could become a criminal law example too. We then went on to look at the elements of how civil law and criminal law differ in regards to, the outcomes as well, and also things like burden of proof, the legal action taken, and the elements of that. So that was learning outcome 1. Now we're going on to learning outcome 2, which is to understand legal and justice systems within a business context. So there'll be some repetition in regards to what we've done in learning outcome 1 as well. So in the learning outcome 2, the indicative content is systems for interpreting and enforcing laws. Looked at legislation, directives, case law, treaties, court structures, the role of government, the role of government agencies, and law enforcement, courts, and correction. So key terminology is the criminal justice system in the UK, and what it does, the elements of the criminal justice system. And it's like it said, it's a collective body responsible for administrating justice in the UK. Also, its element is to try to avoid any sort of it involves a lot of institutions, like the police, Crown Prosecution Service, and the UK's prison service. So the court system in the UK is really important because there are different types of courts that deal with different jurisdictions. And the main types of jurisdiction in England and Wales are things like criminal law, civil law, family law tribunals, military coroners, and the different levels of court within each one, and what each one does as well. So there's different courts, which we'll go through a little bit later. The prison system in the UK, why that's managed by HM prisons, Majesty's Prison and Probation Service, HMPPS, and it's overseen by the Ministry of Justice. And prisons are divided into different categories, which we'll look at. When someone enters the system, they usually initially be sent to a local prison, and there are where a defendant will be assessed, usually local to the area of the court where the trial is. Once a person has been convicted and has been sentenced, they will normally be sent to a dispersal prison where the sentence will be served. So which we'll go through more in regards to that. Just to give you a little bit of an idea, there are 117 prisons in England and Wales. 104 are public prisons, which are run by HMPPS, which is Her Majesty's Prison and Probation Service, and 13 are private prisons, and they're run by companies such as G4S, Sodexo, and Serco. So I'm going to give you a little bit of statistics behind it as well. The imprisonment rate for England and Wales is the highest in Western Europe. 40,000 people were sent to prison in 2020. Around 63% have committed a non-violent offence and 44% were sentenced to 6 months or less. England and Wales have more serving life sentence than France, Germany, Italy, and Netherlands, Poland, Spain, and Sweden combined. As we mentioned just recently in the news, it's identified that prisons are hugely overcrowded, and it's up to 88%, at the moment. So that's why they had a lot of issues around the overcrowding of prisons, and the staffing has been reduced phenomenally, and the prisons are overpopulated. So what they've decided to do as an early release, they've released people. So that's in the news at the moment. So it's quite recent at the moment. Okay. The next slide is there's 2 videos on there that you can watch in your own time. And the first one is looking at the UK judicial system, how it works, why we have this UK judicial system, and the processes and what involves the judicial system. The second video on there is quite interesting, which is what I've just been talking about, is prisons in England and Wales are facing chronic overcrowding crisis, why that's the case, why that's so important now that prisons are facing an overcrowding element, and what is being done about that. So that is another video that you can watch in your own time, and they're both really interesting. They're about 5 minutes each. Have a look in your own time. They're interesting in regards to what's happening in the prison service, in regards to the criminal justice service, and why there's more work needed around that. So have a look at the videos in your own time. Just go onto the links there, right click and open the hyperlink, and it will identify that each video for you so that you can watch in your own time. So we're going to look at understanding legal and justice systems within a business context. So legal and justice system are fundamental function of every business, to be honest. They provide, a framework for what businesses can do. And businesses must follow that. They must focus on the legislation in place, and it's crucial that they follow and comply with the laws that are in place. And we're going to be looking at key concepts and legal justice system as we go along in this learning outcome. The role of legal systems in business. So, as we said, business law focuses on many regulations governing businesses and organizations, both locally and globally, in areas like contracts, taxation laws, intellectual property rights, and dispute between parties, as we mentioned in Learning Outcome 1. So the key roles of legal systems in regards to businesses, things like regulation of business practices, protection of rights, which we looked at in regards to looking at the element of how rights are protected for individuals, and the importance of business law, you know, as stakeholders, employees, enforcement of contracts we looked at in Learning Outcome 1, in regards to how a contract is enforced or breach of contract. Dispute resolution, instead of going to court, they resolve the disputes, ADR, and ensuring that there's fair competition, so making sure that legal systems enforce competition laws and prevent any sort of price fixing or business practices. So 2.2, the justice system and the business. So as we mentioned, business law creates a structured environment in which companies operate. And these regulations must be followed, you know, and identified, and make sure that companies comply with these, you know, and we need to make sure that, you know, the laws are followed, but also that, you know, regulations and policies are put in place so that individuals follow them. So we have the civil justice system when we're looking at business, and this justice system looks at handling disputes in regards to any sort of disputes from employees or in regards to any businesses. And this is where civil disputes between individuals and organisation are often involves compensation. No one is sent to prison for this. And the relevance to business is that it rely on civil justice system to resolve any sort of commercial disputes. Maybe it be breach of contract, it may be employment law, any sort of injury disputes that are happening within the workplace. And then we've got criminal law justice, which relates to offences that are and breaches that negatively affect society as a whole rather than one person. So, you know, we look at elements of, you know, things that happen within the workplace, and why it's so important when we look at elements of, you know, when we look at businesses and criminal law. And its business interact with criminal justice system, making sure that they are not committing any sort of crimes, and any sort of issues of money laundering, bribery, you know, that would fall within the criminal side of it. They need to make sure that they are not committing a criminal offence. It could be money laundering, it could be fraud for businesses, it could be health and safety violations, it could be, for this you would get a custodial sentence, a fine, or any sort of a community order if any of these are breached. So alternative dispute resolution. Alternative dispute resolution is used to describe ways of resolving a dispute without having to go to court. There are many different forms of ADR, but the one thing that they have in common is that all potential to resolve dispute without any court involvement. And this is why it's referred to as an alternative to litigation, for example, going to court. And, you know, there are some different forms of ADR. Firstly, you've got adjudication, mediation, and arbitration and expert determination. And ADR will depend on how it works. And in regards to business, it could save time and it could save money and confidentiality, and, you know, try to protect the reputation of the business rather than going to court. So companies like to take the route of ADR and mediation, because, you know, going to court is a lengthy process. It's very costly and can cause bad feelings between the parties. And also, you know, for some people, the process of going to court is stressful and intimidating. On the other hand, you know, ADR is much more quicker process and can be completed within like 28 days, and it's more cost-effective solution. So businesses, organization, and people try to do that to prevent their reputation, but also, you know, people that don't want to go to court as well, which is important. So the 2.3 types of business legal cases in justice. So business encounter many legal cases, you know, so there are many different ones that are encountered in regards to this. You've got things like, you know, You've got contract law, which is revolves around the creation and enforcement of cross-border and domestic agreements between businesses and individuals. You've got employment disputes, and defines the rights and responsibilities, of employees and employees in the workplace, like wrongful dismissal, wage disputes. You've got intellectual property, which looks at protecting trademarks, patents, governs the creative ideas and products. Corporate fraud, and that focuses on legal aspects of forming, structuring, and operating a business, and that's a criminal case as well. And, it looks at elements of tax evasion as well, health and safety violations, and that's failure to comply can result in criminal charges for businesses. Also, other ones can be things like antitrust laws, which encourages fair competition and prohibits any sort of formation of monopolies. And international business law as well refers to policies and regulations that regulate trade across national borders. And as we mentioned in Learning Outcome 1, you've got consumer protection, which protects customers from deceptive sales practices and dangerous products. So, when we look at importance of business, the types of various legal cases, it's really important to make sure that, it's implemented within the workplace. Importance of compliance and awareness, and this is really important in regarding, business law offers several benefits for companies and stakeholders, the public and society at large. First, it promotes ethical conduct. Company leaders and employees must use their legal guidelines to inform decision-making and navigate complex issues. For example, the Occupational Safety and Health Act, or OTHM, requires companies to provide safe environment for employees. Similarly, equal opportunity in employment laws mandate the companies have non-discriminatory hiring practices. Legal framework also helps businesses operate smoothly. For instance, say two friends decide to launch a company together, they create a co-founder agreement that defines their rights and splits their equity in the business. The legal document prevents conflict if the relationship deteriorates or the company dissolves. Robust contracts, intellectual property protections help companies avoid costly legal challenges. It is really important that, the legal understanding is any sort of legal and justice systems is critical for any business. Key reasons for businesses to maintain legal awareness: risk management, as we mentioned, understanding managing legal risks; reputational management, compliance with legal requirements, making sure that you comply with them, making sure that you are taking on board what is identified and what you need to look at in regards to, what the principles are; operational policy, making sure there's clear understanding of legal environment that enables businesses to, navigate in regards to the legislation, and avoiding any sort of criminal liability as well, making sure that you are following the legislation to avoid any sort of issues of fraud or regulatory violations and any sort of elements of corrective action that needs to be taken. So in conclusion, the legal and justice system forms the backbone of a well-functioning business environment. They ensure that businesses operate with a structured and fair framework, providing remedies when wrongs occur and enforcing compliance with laws. By understanding and adhering to these systems, businesses can protect themselves from legal risks, resolve disputes efficiently, and maintain their reputation as lawful and responsible. Now we're going to go on to 2.1, which is looking at explaining what is meant by the term legal system. So the UK legal system is a set of institutions, rules and procedures that govern the administration of justice. It ensures that disputes are resolved and laws are enforced, and individuals are protected in that jurisdiction. It's a framework of rules, procedures, and institutions to interpret and enforce the law. And it's there to help individuals as well, make sure everyone is protected within the UK. And, there are elements of, the fact that, it combines legislation and the creation of any precedent. So it governs the behavior of human beings, within a civilized system and make sure that everything is maintained and the laws are regulated and followed. Components of the legal system. Key components of the legal system that we're going to go through, so you've got a better idea. So the key components, there's so many in regards to that. First one is legislation, what legislation is and why it's so important in regards to being a component of the legal system. So within the UK legal system, legislation plays a crucial role in forming the basis of law. It provides a framework for understanding legal rights and obligations, as well as serving as a reference for practitioners and scholars. So it's really important, you know, the significance of legislation in the UK lies in its vital component of the UK's unwritten constitution. Some key reasons for the importance of legislation are that it governs the population's behaviour by establishing legal rights and obligation. It protects individual and collective rights by providing a clear framework for citizens and authorities, and enables democracy, addresses social, economic and environmental matters, and it contributes to the legal certainty and predictability by establishing clear rules and procedures for implementing any sort of laws. And in the UK, we have primary and secondary legislation that refers to an element of legislation that is important. The example that they've given there is the Company Laws Act 2006, which governs any sort of company legislation in regards to elements of how the companies work. The next one is directives, and these are passed legal acts issued by supranational bodies such as European Union, which governs any sort of legislation. And however, you know, the example we've got here is the EU General Data Protection, GDPR, which is a directive, and its influence on things like personal data and how it's protected. The role in the legal system, directives play a significant role in shaping the national laws and protecting individuals' employment rights and environmental rights. We've got case law, another really, really important component of the legal system in regards to what elements that follow. So case law in the UK plays an important role in development and interpretation of legislation. Case law refers to the collection of legal decisions made by judges in courts which interpret statutes, regulations, and previous case decisions. These decisions create a body of law known as a precedent that future cases must follow. In the UK, the legal system is based on principle of stare decisis, which means that the decisions made by higher courts are binding on lower courts. This ensures consistency, stability, and predictability within the legal system. And it's, you know, case law is really important in the UK, and it's an essential element. And there are parts that it helps. It supplements legislation. So when legislation is ambiguous and you don't understand it or silent on a particular case law fills in the gaps by interpreting the legislation, providing guidance. It promotes consistency and fairness by following precedents. Similar cases are decided consistently, making the legal system more predictable and ensuring that individuals are treated fairly and equally. It also allows for legal development. So case law allows the law to adapt and develop over time as judges reinterpret legislation and apply it to new situations or technological advances. Case law and legislation, going back to it, are both sources of law in the UK, and they work together to create a functioning legal system. So, you know, an example we've given there is a really good example, a really famous case of Donoghue and Stevenson, and in this case established the principle of negligence and the neighbour test, laying down the foundation for modern tort law. The court in this case held that a duty of care existed between the ginger beer manufacturer and the ultimate consumer, even though there was no direct contract between the parties. So this is something you can have a look at in your own time, the case of Donoghue and Stevenson. The next element of the principles is treaties and why these are important in regards to the UK economy. So what a treaty is, a treaty is a formal legal binding written agreement concluded by sovereign states in international law. International organizations can also be party to an international treaty, and a treaty is binding under international law. Some examples of treaty is we have the Treaty of Lisbon, we have the Treaty of the Treaty of Paris. These are some of the important ones, and they are agreements internationally between the states, and they are governed by international law. Treaties become part of the legal framework and ratified by national law. So they are important in regards to implementing any sort of laws which are internationally based. So looking at, finally, looking at the summary table, so we've got the term, which is legislation, and this is formal laws enacted by a legislative body, for example, Parliament. The example we've given for businesses is Companies Act 2006, and the role in the legal system, it establishes statutory laws governing business and society. Now, directives, again, definition is legal acts issued by supranational bodies like the EU. And the example is GDPR, which looks at protecting individuals' personal data. Then the role in the legal system, it requires national implementation and shaping domestic law. Case law, the law developed through judicial precedents and decisions. And the case example we gave was the famous case of Donoghue and Stevenson, which have identified the element of negligence. And then the role in the legal system, it provides legal rules based on court decisions and precedents. And then treaties, formal agreements between internationally and our sovereign states under international law. And the example, Treaty of Lisbon, Treaty of Paris, role in the UK influences national laws, especially in areas like trade and rights. So to conclude that, we've looked at the legal system serves as a foundation for interpreting and enforcing laws in a country. It encompasses various components, including legislation, directives, case law, and treaties, which work together to regulate society, protect rights, and ensure justice. In the UK, each of these components plays a crucial role in shaping the legal landscape, especially in business law, where compliance and understanding of elements are essential. So it's really important when we look at elements of compliance that each law, each element is covered with, each area is covered by and each business is complying with the laws as well. So now we're going to look at 2.2, which is to describe illegal court structures in the UK. So the court system in the UK has 5 levels: Supreme Court, Court of Appeal, High Court, Crown Court, and county courts and magistrates' court and tribunals. And what we're going to do, the UK system follows a common law framework, which I've just mentioned, and looks at hierarchical levels, so from top level down to the lower level. And it's divided into primary areas, so criminal courts and civil courts, though some courts have jurisdiction over both types of cases. So the court structure, the criminal courts. So we've got the first one is the magistrates' court. So the magistrates' court is a court of first instance. It deals primarily with criminal cases, but it has some limited jurisdiction in respect of some civil matters. The magistrates' court also deals with the first appearance of any defendant charged with a criminal offence, and they deal with procedural issues and hear initial bail applications. The magistrates' court deals with all cases involving summary offences. Summary offences tend to be less complex and less serious than other types of criminal offences. So do not require trial by jury. For example, most motoring offences are summary offences. The Magistrates Court also has jurisdiction to hear cases involving offences triable either way, which are things like theft and burglary. In these cases, defendants do not have the right to insist on being tried in a Magistrates Court, but the Magistrates Court can accept jurisdiction for the case if they feel it's appropriate. For triable either way offences, the defendant can insist on trial by jury in the Crown Court. Where a triable either way case is too serious or too complex to be tried by magistrates, it must be sent to the Crown Court for trial. The Magistrates Court has limited sentencing powers. In particular, the Magistrates Court can only order a custodial sentence of up to 6 months or up to 12 months in total if the defendant has committed multiple triable either way offences. When determining whether the Magistrates Court has jurisdiction to hear a triable way offence, the magistrates will consider the seriousness of the offence, any relevant prior convictions. They will also look at whether the sentencing powers they have are likely to be sufficient to deal with the case. If the Magistrates Court believe their sentencing powers are insufficient to deal with the case, they will reject jurisdiction for the case and the case will be sent to the Crown Court. And this is actually known as allocation procedure. And that's the criminal side of it. So the next one we're going to look at is the Crown Court in regards to the criminal side. So the Crown Court is typically a court of first instance. It considers criminal law cases. It deals with serious criminal offences and only hears cases where the defendant is accused of committing an indictable offence or a more serious triable either way offence. Indictable offences are very serious offences such as robbery, rape and murder. Triable either way offences are that can be considered by the Crown Court or by Magistrates Court depending on the seriousness of the offence. A good example of a triable either way offence is theft. In some cases, theft will be considered a serious criminal offence because the value of the property that has been taken and because of the circumstances in which it was taken. For example, the defendant abused the position of trust. These cases would be considered by the Crown Court if a defendant appropriated a low-valued item from a supermarket. For example, a bar of chocolate, it is likely to be considered by the Magistrates Court. The allocation of triable either way offence it's heard at the Crown Court. Court of Appeal. The Court of Appeal is split into two divisions, the Civil Division and the Criminal Division. The Civil Division hears appeals on civil matters and the Criminal Division hears appeals on criminal matters. Like the Supreme Court, the Court of Appeal only hear appeal cases. It will only hear cases that involve question of law. The type of appeals can be heard by the Court of Appeal. So it could be things like, it could be elements of any sort of cases that are complex, it could be cases that are value of less than 100,000. Then we've got the Supreme Court, which is one of the highest courts. So apart from cases being concerned with European law or the European Convention on Human Rights, the Supreme Court is the highest appeal court on civil and criminal matters in the UK. The Court of Justice of the European Union deals with cases concerning the interpretation of compliance within EU law. The European Court of Human Rights has jurisdiction for cases involving the interpretation or application of the European Convention on Human Rights. The Supreme Court only hears appeal cases that involve a point of law which is of public importance. It has appellate jurisdiction only, so no cases, no matter how important, can start in the Supreme Court. The type of appeals that may be heard there is things like, anything that would involve an error in the point of law, and it could be cases of great importance to the public. So civil courts, we've got the first one is the county court in regards to the civil courts. So the county court hears a wide range of civil cases. It is a court of first instance, but also hear appeals in some circumstances. Claimants in civil cases can choose to commence proceedings in the county court. The county court tends to hear cases that are less complex and of a lower monetary value than those considered by the High Court. As a general rule of thumb, cases with a value of £100,000 should be commenced in the county court. Personal injury cases with a value of less than £50,000 should also be commenced in the county court. Then the next one we've got is the High Court. So the High Court deals with more complex and high-value cases and divided into three divisions. You have the Queen's Bench Division, Chancery Division, and Family Division. Collectively, the three divisions of the High Court hear a wide range of civil cases. It's important to understand in many cases, the High Court and the County Court have concurrent, which is parallel jurisdiction to hear civil cases. This means that both courts have jurisdiction to hear the same types of cases. Civil cases with a value of less than 100,000 or less than 50,000 for personal injury cases should be commenced in the County Court, Civil Procedure Rule, CPR 1998. Where cases have a value of more than 100,000, more than 50,000 for personal injury cases, the claimant can choose to commence the proceeding in the Queen's Bench Division, the Chancery Division, or the County Courts. The case should be commenced in the High Court where the case has complex facts or the outcome of the case has the element of public interest and the claimant believes the High Court is a suitable court. In other cases, the case should be commenced in the County Court rather than the High Court. Court of Appeal. So the Court of Appeal consists of two divisions, as we mentioned, the High Court and the County Court. It reviews lower courts' decisions, and its element is to look at any sort of if there's any correct application of the law being upheld. Then we've got the Supreme Court, which was established in 2009, and it was a judicial court, and it's the final court. And it hears appeals from the Court of Appeal and the High Court. Then you have special courts and tribunals. So these are elements that, there may be elements that they are tribunal services and they will deal with issues around special courts. So these could be things like employment tribunal. You could have, the family courts tribunal. You could have elements of the commercial courts as well. And some civil cases are considered by tribunals. Tribunals are specialist judicial bodies that adjudicate disputes in specialist areas. As we mentioned, maybe employment, family. Technically speaking, tribunals fall outside the formal court structure, but they play an important role in the administration of civil justice. The Tribunals, Courts and Enforcement Act 2007 introduced a two-tier tribunal. Generally, the first-tier tribunal acts as a court of first instance, and the upper tribunal deals with appeals from the first-tier tribunals. There's also separate employment tribunal that look at wide cases, and you have immigration tribunals as well. So a summary of table of the UK courts. Magistrates' jurisdiction is lower criminal courts, types of cases, minor criminal offences and appeals to Crown Court. The Crown Court is a higher criminal court, deals with more serious criminal offences, and it goes to the Court of Appeal. The County Court is a lower civil court, types of cases, civil disputes, and it goes to the High Court or Court of Appeal. The High Court is a higher court, civil court and appellate authority, complex civil cases, business disputes, and it's Court of Appeal. Then we have the Court of Appeal, Appellant Court for criminal cases, appeal from the Crown Court, and it goes to the Supreme Court, Court of Appeal for civil division, appeals from the County Court and High Court, and it goes to the Supreme Court. And the Supreme Court is the highest court, and it doesn't go anywhere. It's identified on points of law. So the UK legal system is highly structured and distinct, and it's got its own hierarchy. Each court plays a vital role in enforcing and ensuring that the law is dealt with fairly and efficiently. So, you know, and there's a hierarchy placed in system, and businesses operating in the UK must be aware of the court structure. 2.3, explain what is meant by the term justice system and why it's important within the UK. So the justice system refers to various agencies, establishments and institutions that are responsible for enforcing the law. These agencies are primarily organised around handling either civil or criminal cases. The criminal justice system is the most commonly referred to and includes law enforcement and correctional institutions, and it's responsible for investigating and prosecuting crimes. So this consists of various bodies. So the key elements of the justice system. Firstly, we've got the government and how they play a big part in this. And the government plays a central role in establishing, overseeing and funding the justice system. Through the legislative and executive branches, the government creates laws and policies and provide oversight for justice institutions. Key responsibilities: they create the law creation, policy and administration, resource allocation, and an example they give: the Ministry of Justice in the UK manages the legal system in England and Wales, ensuring everything is fair and equal. Then we have the role of so we looked at the government, the role of government agencies. So, you know, they are part of government and usually provide government service rather than decide policies. So you've got court administration, you've got prosecution, and you've got offender management, so the National Offender Management Service, which we're going to look a little bit more at later. So law enforcement. The law enforcement agencies is the activity of some members of government who act in an organised manner to enforce the law by investigating, deterring, rehabilitating or punishing people who violate the rules and norms governing the society. And the key responsibility could be crime prevention and investigation, so police forces are responsible for that. Public safety, law enforcement agencies are responsible for that, and executive of court orders, so police and other agencies that, you know, issue warrants, restraining orders and search warrants. And the example they've given is the Metropolitan Police London, one of the UK's largest forces for maintaining law and order in the UK. The summary here identifies the UK law, so the role of the government. It identifies the role of government agencies and law enforcement. So have a look at that in your own time, because we've been through that. I don't want to repeat that again. In conclusion, the UK justice system is a collaborative framework involving the government agencies and the law enforcement working together to ensure laws are upheld and offenders are prosecuted and justice is delivered. Each element has a distinct but interrelated role in maintaining the rule of law and ensuring fairness, equality and effective justice for all citizens. So 2.4, describe a justice system in the UK. The justice system made of several interrelated components, including courts and correctional services. Below is a description of the courts work. So we've got first, the courts in the UK are central to the UK justice system. They provide the forum for disputes to be resolved, laws to be interpreted, and penalties to be enforced. The court structure is hierarchical, as I mentioned earlier, and we went through it, ensuring that cases are heard at the appropriate level based on their complexity and gravity. So types of courts. We have Magistrates Court, Crown Courts, Court of Appeal, Supreme Court, which we've all gone through, so you've got a better idea of what they deal with. Civil courts, you've got County Courts, High Court, Court of Appeal, Division, and Supreme Court. Again, we've gone through them at the top and identified each element of them. Functions of the court, they are there to interpret the law. Courts interpret legislation, ensure that the law is applied correctly to individual cases. Dispute resolution, so courts resolve disputes between parties, whether in criminal matters or civil matters, and settling precedents. So higher courts, particularly the Supreme Court, set laws, precedents that lower courts must follow. An example they've given in criminal cases such as R and Smith, the Crown Court would hear the case if the if it involves serious offences like armed robbery, while serious less cases such as shoplifting might be heard in the magistrates' court. So looking at 2.2, correction in the UK system. So the correctional system is responsible by carrying out sentences handed down by courts, including imprisonment, probation, and community service. It focuses on punishments, rehabilitation, and reintegration of offenders into society. So you've got types of correctional services. So there are many types of prisons within the UK, both private and publicly owned. These are defined by the nature of prisoners they keep. So you've got they split into local and dispersal one. A local prison is where you sent initially, where the assessment of each takes place, and then you are sent to a dispersal prison. All prisons are given a category, which we're going to look at. So a category sets out how the prison system will handle you. At most serious end for the male prisoners are category A prisons. These are defined as being those whose escape would be highly dangerous to the public or national security. Offences may result in consideration for category A or restricted status, including things like attempted murder, manslaughter, wounding with intent, rape, indecent assault, robbery, conspiracy, class A controlled drug. Unless you are a category A prisoner when you are first committed to prison, you will automatically be categorized as category B prisoner, who are defined as those who do not require maximum security, but for whom escape needs to be made very difficult. So if you are likely to be held on remand, you will be set as a Cat B prisoner. After some time in prison, you may be as a lower profile prisoner and will be categorized as Cat C, who are defined as those who cannot be trusted in open conditions, but who's unlikely to try to escape. Finally, there are category D prisoners who are held in open prisons, which have a more relaxed regime. Category D prisons are defined those who can be reasonably trusted not to try to escape and are given the privilege of an open prison. It takes some time to progress through the various categories, and it is first offence and it was a non-violent or drug-related, such as fraud, you may be categorized as Cat D within a month of being sent to prison. The speed of progression depends on how you have reacted to the prison rules and regulations and how you have behaved while you are in custody. Probation services. So you have community rehabilitation and you have post-prison report. The National Probation Service is a statutory criminal justice service that manages offenders under probation supervision who have been assessed as presenting a high risk of harm to others. The National Probation Service would work around 30,000 offenders a year, supporting their rehabilitation while protecting the public. Their priority is to protect the public by effective rehabilitation of high-risk offenders, by tackling the causes of offending and enabling offenders to turn their lives around. By tackling the National Probation Service was set up in 2014, along with 21 community rehabilitation companies. You've got post-prison support. Probation officers help former inmates reintegrate into society after their release, ensuring they meet the terms of their release and avoiding reoffending. Then you've got the Youth Offending Institution, and they are usually called YOIs for short, and you will serve your sentence in a youth offender institution, and you could be on its own or part of an adult prison. And the age limit for young offenders institution is boys between 15 and 17 and young adult mates between 18 and 21. And they focus on education rather than punishment. Functions of correctional service is to rehabilitate offenders, to make sure the purpose is retribution. It could be, to avoid any sort of actions to rehabilitate them, aims to rehabilitate offenders, and public safety, to protect the public from any sort of safety in regards to it. Example, an offender convicted of theft might be sentenced to 6 months in prison, to category C prison, where they participate in job training programs to prepare for reintegration into society. After release, they may be placed under probation to ensure they don't reoffend. And a summary of the table of justice. So we've got courts. Their description is the institution responsible for interpreting the law, resolving disputes and imposing penalties. Example, Magistrates Court, Crown Court, High Court and Supreme Court. And the correction is the institution services responsible for carrying out sentence rehabilitation of offenders and ensuring public safety. And that's category A, prison, high security probation services, community rehabilitation and young offenders institutions. To conclude, the justice system in the UK is a comprehensive structure that includes courts and correctional services. And each play a vital role in upholding the law and making sure that everything is safe for elements of anyone, any public. The courts provide a legal framework for interpreting laws and resolving disputes, while the correctional system enforces penalties and focus on rehabilitating offenders, helping them reintegrate into society and to prevent any sort of future crime. So we've finished learning outcome 2 now. I just want to give you an overview of what we've gone into. These are the references used. And there's some articles there that you can refer to in your own time, and they are really good on health and safety executive and consumer rights. So to finish off, we've looked at in learning outcome 2, legislation, directives. We've looked at systems for interpreting, enforcing laws, case law treaties. We've looked at the court structures down from the highest hierarchy, which is the Supreme Court, down to the Magistrates Court. We looked at what they did, the role of the courts, what kind of criminal offences it involved. We looked at the role of government agencies such as the government itself, but also agencies such as the police, CPS, law enforcement, courts and correction. So we looked at the probation services, we looked at elements of youth offending institutions, we looked at rehabilitation, retribution, how they rehabilitate people into the society. We looked at the criminal justice system in the UK and the court system and prison system. And also there were some videos that you could go on to and some articles that you can read in your own time that you need to refer to. Plenary, please refer to ebooks and journals on Moodle for this unit. Further reading, I've done a research briefing there on the criminal justice system in the UK. So that could be, it's a short guide to the criminal justice system. Have a read of that, it's really interesting. If you have any questions, please email learnerwork@ukvarsity.co.uk, and submission of the assignment to be done on learnerwork@ukvarsity.co.uk. Assignment submission is after 2 weeks of completion of the units and its delivery. So we've done learning outcome 1, we've done learning outcome 2, and the next learning outcome is learning outcome 3. And if you have any questions, please refer to learnerwork@ukvarsity.co.uk. This learning outcome 2 and learning outcome 1 are both recorded and will be put onto Moodle for you to refer to, and also to look at if there's any sort of additional reading, any ebooks, any journals, please refer to Moodle. Any questions about any of the sessions, learning outcome 1 or 2, please email learnerwork@ukvarsity.co.uk. Thank you for attending today's session, and I will see you in the next session.